Representative Holly is recognized to speak to the bill.
Thank you, Mr. Speaker. I am still hopeful. I rise today and ask that you join me in firmly voting no to Senate Bill 1EX. Georgia experienced record exponential growth in the last decade, especially among African American residents, via the U.S. Census data. More than 1 million new residents had moved into the state in the last 10 years, equating to a 16% jump in Black population growth. In December 2021, when the governor signed SB 1EX and HB 1EX into law, lawsuits were filed on behalf of disenfranchised Black citizens to recognize that by not drawing additional Black majority voter districts that recognize this extensive growth, this House, along with the Senate, had violated Section 2 of the Voting Rights Act. The legislature had purposely been diminishing the voting strength of Black voters by redrawing these maps without adding majority Black voting districts, in direct violation of the landmark civil rights law, whose Section 2 was recently upheld by the U.S. Supreme Court in Alabama's test case, Allen v. Milligan. For the press and the viewing public of today's hearing, Section 2 of the Voting Rights Act of 1965 prohibits voting practices or procedures that discriminate on the basis of race or color. Therefore, by not accounting for the additional 1 million new Black residents who had moved into the state, by drawing districts reflecting this incredible growth, the damage had already been done. In Judge Steve Jones's 516-page decision, he made explicitly clear that the Georgia House and Senate must reconvene to draw new maps to remedy the illegality of the previous maps by creating 2 majority Black Senate districts, along with 5 majority Black House districts. Judge Jones's decision also affirmed the plaintiff's recognition as to how hastily these unlawful maps were rushed through the process, and how the Republican-led legislature certainly had ample time to prepare remedial district maps in the event of an overturning. As noted by the Senate Minority Whip from Augusta during these recent hearings, the Reapportionment Committee, again, hastily rushed through the process, deflected Judge Jones's specific order to correct districts in violation of Section 2 of the Voting Rights Act, and instead spent a total of 3 hours to render a decision on 22 months of complex litigation. Further, the African-American attorney senator noted still that the Senate Committee on Reapportionment had outrightly refused to recognize African Americans as the chiefly discriminated target of the state's voter suppression exercises throughout history, regardless of party, as continued under these hastily drawn maps. 3 hours is not enough time for a lot of necessary considerations to comply with a federal court order. 3 hours does not allow for ample public comment by local citizens, and more particularly by the citizens of color most impacted by these still discriminatory maps. During the committee hearings, no metrics were revealed as for measuring the precinct level or regional socioeconomic activity, nor any particulars relevant to maintaining community interests. Perhaps a careful review would have given Republicans a better understanding, a more acutely aware realization of the serious harms inflicted on voters, so that they too might fully value the historically tempered rationale of Judge Jones, a double dog graduate of University of Georgia and appointee of former Governor Zell Miller, and instead Those 3 hours were spent reviewing a Republican redrawn map where the majority party pulled voters from unaffected districts for a partisan advantage, rather than correcting the 10 districts found to be non-compliant with the Voting Rights Act. Those are districts 10, 16, 17, 25, 28, 30, 34, 35, 43, and 44. I myself, as a former resident of a multiple mid-cycle gerrymandered district, one that was redrafted more than 3 times in under a 5-year period, I remember the silencing feeling of knowing voters like me and those in my surrounding neighborhoods had an electoral system that continued to stack up against us year after year. For example, my nearby Senate District 17 that was rather dramatically cut far outside of Henry County into faraway places like Madison, nearly 50 miles to the east. According to this redrafted map, while Senate District 17 has been recut north into Senate District 42, it is still unlawfully cracked, stripping away the uniformity of heavily black residential neighborhoods in favor of a gerrymandering scheme that effectively weakens the voice of targeted African American voters in Henry, Clayton, and DeKalb counties. Yet the committee chose to take voters in non-disenfranchised areas and add them to districts where voters were already found to be disenfranchised. Also, the committee failed to pass the Senate Bill 4EX that had followed the court's plan to remedy this issue by creating 2 districts which would enable black voters to elect a candidate of their choice. Sometimes, old habits are hard to break, even for those who believe they have the best of intentions. It's one of the core reasons why our system of government respects a separation of powers, because checks and balances are deemed necessary against potential abuses or discretion, whether such acts are intentional or unintentional. It's also one of the reasons why the U.S. Supreme Court held in Section 2 that election practices which deny or abridge persons' right to vote on the basis of color are inherently in violation of the law. Essentially, the court instructs that it is better to accept wrongdoing and start over again rather than try to spend 3 hours defending the constitutionally indefensible. As President Lyndon Baines Johnson, the one leader who arguably by passing such sweeping voting and civil rights laws caused such a seismic exodus from the Republican Party to the Democratic Party, stated as he signed the Voting Rights Act into law, to quote, "Under this act, if any county anywhere in this nation does not want federal intervention, it need only open its polling places to all its people. And I pledge you that we will not delay, and we will not hesitate, and we will not turn aside until Americans of every race and color and origin in this country have the same right as all others to share in the process of democracy. And so we will move step by step, often painfully, but I think with clear vision along the path toward American freedom," end quote. My colleagues, let us not be dismayed about the tremendous progress which has occurred in our state and nation in the 58 years since the passage of this great act. This House chamber alone has seen a vast browning among its membership. Georgia has the largest concentration of elected black state lawmakers of any state in the nation, proudly led by a principled gentleman from Garden City. We recently passed historic legislation together to eliminate a slavery-era policy like citizen's arrest, which was responsible for hundreds of lynchings. We passed a centuries-overdue hate crimes bill. We have also seen a candid softening of relations within our chamber between men and women who would not have been in the same breathing space had the rules remained unchanged in the directives of Georgia's earliest founders. We have had hard conversations about the direction of our state, the replacement of racially charged symbols of division, and even the adoption of a state flag in some recent years. And there is still ample time to get it right, even on this remedial bill before us today. And should this body pass another discriminatory set of maps in violation of long-standing American laws, may God be with our Federal Circuit Court, who I know will regard citizenship over partisanship and render immediate justice in the spirit of Reverend James Orange, Miss Ella Mae Brayboy, Congressman John Lewis, and freedom fighters Coretta Scott King and Stockbridge's own born son, Reverend Dr. Martin Luther King Jr. As Scripture fervently reads, "Let justice roll down like waters, and righteousness like an ever-flowing stream." Thank you.
The gentleman has yielded the well.